point of order request from Senator Wilborn.
Thank you, Madam Chair. I requested a bill introduction on 3064, had to do with the immunity of the grand jury, and I am going to withdraw that request because it has been filed in Fed and State in the exempt committee.
Thank you. With that committee, then we will turn to opening the hearing on Senate Bill 434, creating exemptions in the Open Records Act for records that contain captured license plate data or that pertain to the location of an automated license plate recognition system. And with that, then we will hear the bill brief from our reviser, Mr. Thompson.
Thank you, Madam Chair. As you mentioned, Senate Bill 434 is dealing with exemptions in the Open Records Act for captured license plate data and the location of automated license plate recognition systems. You'll see 3 sections in the bill, all part of the Open Records Act. The first is KSA 45-217. That's the definition section for the act. You'll see new subsection A there in line 10 of the first page, then italics. Defines what an automated license plate recognition system is. Most of you have seen these or heard of these. It's the high-speed cameras combined with algorithms used to convert images of license plates into computer-readable data. So that's what we're talking about. And then subsection C there in line 17, also in italics, captured license plate data is the global positioning device coordinates, date and time, photograph, plate number, and other data that's captured by or derived from those automated license plate recognition systems. So you've got both the system and then the data that's derived from it, and the records related to both of those are what we're talking about. Section 2 then gets into KSA 45-220. That's, of course, our open record statute about procedures for obtaining access to copies of records. The new subsection J is added, and that is on page 5, around line 14. This would allow or provide that a request that is made for records that contain captured license plate data or that pertain to the location of one of those plate recognition systems that is submitted to a state or local law enforcement agency or a governmental agency shall be directed to the state or local law enforcement agency or governmental agency that owns, leases, or contracts for the automated license plate recognition system. So rather than directing your request to someone who may have a record of something from those systems or know about the location of those systems, your request is required to be directed to the agency that actually owns, leases, or contracts for the system. You have to go to the source, essentially. And you'll note that we have a similar provision for that right above it in subsection I. You did that a few years ago with files that come from law enforcement agencies. Multiple law enforcement agencies may have the same files about the same people, but you go back to the agency that maintained or kept those files. So that's the model we followed there, just directing it back to the source rather than a secondary or tertiary source. Finally, we get section 3, which is a statute most of you are familiar with if you've been around our open records reviews. This is KSA 45-221, the list of records of a public agency that are not required to be disclosed. So essentially all the exceptions to the Open Records Act are in here. Well, not all of them, but many of them. The bill adds a new subsection A55. Yes, there are 54 other ones there already. We're on page 12, line 33. That's the new A55. And it provides that a public agency is not required to disclose records that contain captured license plate data or that pertain to the location of an automated license plate recognition system. So again, it's protecting or not requiring disclosure of the data that comes from the system or the location of the system, but other records would of course still be open records. So I think that covers it. I'll stand for questions.
Thank you, Mr. Thompson. Committee, are there questions? I do have one question, and this might be for the proponents. On page 12 in subsection 55 there, we're talking about records of a public agency, and that language doesn't specifically mirror what we see on page 5 with where you have to make the request. It's just different language. It says records of a public agency, and then on page 5, subsection J, it talks about governmental agency or state or local law enforcement agency. So I'm wondering if there's a reason that it doesn't those doesn't mirror each other.
Madam Chair, I can, just from the statutory perspective, the term public agency is the broader term under the Open Records Act, and it's used in all those exceptions in A, well, not all, but many of them, 1 through 55 now. I think the more specific term is used on page 5 because it is describing more particularly who the request would go to. We could say, at least in the first part, submitted to a public agency shall be directed to the specific state or local law enforcement agency. So we could do that. We didn't do that in some of the others, but I could see some value to the broader general term, and then the more specific term. And then in 45221 A55, you would definitely want the broader term, right? Because if for some reason a non-law enforcement agency had this information, you wouldn't want them to be required to disclose it if you adopt this policy. But under the first provision, the second provision on page 5, you kind of might want the same idea. Record requests that are submitted to a public agency about these topics should be directed to the specific agency. So if you were going to do something along that line, we might change line 16, but not change the later lines. So let me look into that a little bit, but I think I see your point. The one is broader, and the other one probably should be broader too, before directing to a more narrow
Well,
place.
and I don't want to get ahead of the policy that's intended by the bill and the changes. So if this is a creature of, statutory construction, and I understand that. So if it is purposeful that we want to direct our requests to certain entities, and it's also then further purposeful that any public agency that gets these requests is protected. So I can see the distinction between the request is made to specific entities, and then the protection is broader, that anywhere this request is made, the records are protected or fall within this exception. So thanks for clarifying that, and we'll probably hear more of that from our proponents. Anyone else with any questions? Yes, Senator Thompson.
Thank you, Madam Chair. Just for sake of clarification, so they can't disclose records that contain captured license plate data or pertain to the location. What could this create any issues with regard to somebody who needs that information for a legal defense?
And this might be a better question for a proponent, but if
Okay.
you have a response, Mr. Thompson.
Sure, Madam Chair and Senator. So the Open Records Act is speaking just to requests from the public for governmental records, right? So if you're in a discovery situation or a court-ordered situation, I think you'd have a different analysis. So I think you could still subpoena records, for example. They're not confidential. They're just protected from public disclosure under the Open Records Act.
Okay.
So if we were making them confidential, then that would be an issue that we'd have to address, whether you could get them in certain cases. But in this case, this is just a general open records concept, should not affect the ability to subpoena them or discover them in a civil or criminal matter, that sort of thing. So
That clarifies it. Thank you. Thank you, Madam Chair.
Thank you. With that, then, we will have proponent in-person testimony from Ed Klump, Legislative Liaison, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Peace Officers Association. Welcome back to committee. Please introduce yourself.
Thank you, Madam Chair. My name is Ed Klump, and I am here on behalf of the three associations the chair listed there. And this is a bill that we brought forward, and it is in response to an issue that arose actually a couple of years ago. And what was happening is KDOT, and a lot of our license plate readers are on state and federal highway right-of-ways, and KDOT was getting open records requests for data. And of course, they didn't have the data. They just had the right-of-way where the devices were located. But they were getting so many of these requests that they became concerned about it. And what they did, they told us until we get this fixed in the Open Records Act, they would no longer authorize us to place license plate readers on the state and federal highway right-of-ways. And so this is in response to that, to fix the problem. And at the same time, we learned that the local agencies were getting a lot of requests related to the license plate reader data as well. So Jason, as usual, has done an excellent job of explaining what's in the bill. I think everything but the why has kind of been explained. So I'll go into that a little bit. So if enacted, what this bill will do, it will protect this license plate data from the open records requests, and it'll protect that data and protect the people whose data we have. And that data generally is only the license plate number, which then through the other systems we can get, the owner information, address, things like that. These generally do not capture, they're not intended to capture the photograph of the occupants of the vehicles, generally speaking. And so it doesn't have that kind of data there. It's only basically the license plate data. We also want to protect the location where these are, because we don't want the criminals filing Open Records Act and finding out where they are, so they can just avoid, going where the system is located. Jason pointed out where those provisions are. Madam Chair, I'll add that if that change were to be made like you were suggesting, I think that'd be a friendly amendment. I don't think we would have any problem with that. But I would point out that on page 5, on lines 18 and on line 17, it does say or governmental agency. So it's not just law enforcement, although that's a little bit different language than what we find in the other section that talks, I forget what the word was there. It's public agency. So one says public agency, one says governmental agency. I think it probably boils down to the same in the long run, but if that wanted to be clarified, that would not be a problem for us. I want to talk a little bit about the value of these tools. Criminals today use technology to victimize their victims. And it is very important that law enforcement also be able to use technology to try to protect the citizens. And this is what we're doing with these license plate readers. The value of these readers are just immense, and I think you're going to hear in a little bit from another proponent some of the data on this. But they have led to very quickly identifying homicide suspects, aggravated battery suspects, where we've been able to take them into custody fairly quickly, which means we have a better chance of recovering evidence of the crime, and we have a better chance of that person not victimizing somebody else in the process. We recover a tremendous number of stolen cars from these systems. These systems will trigger when a car goes through that is in the system as being stolen or a wanted person. It's used with Amber Alerts and a variety of things like that, where we have license plate information entered into the computer system that we're looking for. And it will trigger those and send an alert to the agency that that vehicle has just went through a particular area where a license plate reader is located. So they're a very valuable tool, and we want to be able to utilize that but still protect the privacy of the people whose data we're collecting. I do want to point out that this protects the data of the license plate and it protects the location data, but it does not make the information on the purchasing of these equipments, what the city spends on them, all those data that the public has a right to know because it relates to the spending of the taxpayers' dollars. That is not closed in this. It's only the data itself and the location information. So, Madam Chair, with that, I think I'll stand for questions at the appropriate time.
Thank you, Mr. Klump. Appreciate your testimony, and we'll reserve questions till all the proponents have had an opportunity. With that, then, we will ask John Goodyear, General Counsel, the League of Kansas Municipalities, to provide his testimony. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee. Good morning. My name is John Goodyear, and I'm the General Counsel with the League of Kansas Municipalities. Grateful for the opportunity to provide testimony today in support of this bill, and Mr. Klump did a tremendous job explaining the value of this, so I'll try not to parrot him too much. But these license plate recognition systems, these readers, have become an important tool used by law enforcement entities all around the state to help investigate crimes, to collect necessary information to aid in these criminal investigations. A typical one we think of is tracking down stolen vehicles. So this bill would add an exception to the Open Records Act, allowing public agencies to withhold the data collected by these systems and the data pertaining to location of these systems. Withholding this data will allow law enforcement entities to strike that appropriate balance between recognizing this as a legitimate use of law enforcement, legitimate use by law enforcement, with the privacy interests. It strikes that an appropriate balance there. And further, withholding data regarding the locations of these systems will help to, I guess, affirm their purpose. If this data was available, as Mr. Klump mentioned in his testimony, criminals would request that data. If they knew they were going to be moving stolen vehicles, moving contraband, they would request the data regarding where these systems are and simply just avoid it on their route. So we feel that withholding data regarding their location is important. So while the general rule under the Open Records Act is that records of public agency are supposed to be open to the public, and that's a good rule, but this legislature has made exceptions in the act when we've recognized that certain records should be withheld because of privacy interests, security interests, and allowing public agencies to withhold this kind of data is consistent with other exceptions that have been made in the act. And for that reason, Madam Chair, committee would ask that the committee recommend this favorably for passage, and I will stand for questions at the appropriate time. Thank you, Madam Chair.
Thank you, Mr. Goodyear. Then next, we will have proponent conferee testimony via Webex from Lieutenant Casey Slaughter, Wichita Police Department. Please introduce yourself and welcome to committee. I'm seeing that he's not on Webex yet, so we will invite, are there other proponent conferees in the committee meeting room or online? Not seeing any. Committee, I would direct your attention to your committee folder. We do have proponent written only testimony from Colonel Herman Jones, Superintendent of the Kansas Highway Patrol. And until we hear that Lieutenant Slaughter is on Webex, we will go ahead and proceed with questions for any of our proponent conferees. Yes, Senator Pyle.
Yeah, I'm not sure anybody can answer this if they want, but I'd like to hear a really good explanation as to why we would prohibit the public from accessing this. I understand there's a cost to delivering it to the public, but what is it that we're withholding from them? A photo of a license plate and a make of a car? I guess I'd just like to hear a better explanation as to what the reasoning is for prohibiting the public from accessing that data.
Thank you. Mr. Klump, please introduce yourself.
Thank you, Madam Chair. Ed Klump, Association of Sheriffs, Chiefs, Police, and Peace Officers. Very good question, Senator Pyle, and the reason for that is that we find that some of these requests are coming where people want to find out where someone else they're interested in has been going. That isn't the intent of these devices. In other words, sometimes a spouse wants to find out where the other spouse is going. Maybe somebody is having an argument with somebody and they would just want to learn more about them. I suppose you could say maybe a political opponent might want to know where you're going to campaign at. I mean, there's all kinds of things that are open to this if we leave it open. And so many states have this provision in their open records to close these records. In fact, most of them that have any laws on license plate readers have this provision in their laws. So it's pretty consistent with what's happening around the country. Yeah. Does that answer your question, sir?
Well, I guess I failed to see on all of that, you know, if somebody is trying to track someone, I mean, I don't know how old the data is or how recent it would be. By the time they go through the requests and the data is gotten, I mean, these readers are probably more on, I mean, you tell me, maybe that's what I'm failing to see, but I don't see these would be on like a local, like a street down off the main path. I would think most of these readers would be like in a Walmart situation or out on the interstate or at a stoplight. I'm just trying to see, I just want to have a better understanding of why the public would need to be prohibited from that. I follow what you're saying, but I mean, if there's so many other easy technological ways to track someone if they really want to track someone today, and then to go through all of that and a data download from an agency.
Well, first of all, these devices are used on local roadways as well. What brought us here was the issue with KDOT and having them on the state and federal highways. But we do have them on local roadways, especially in the major metropolitan areas, because that's where a lot of the crime is occurring, and that's where we get the value of these devices in solving crimes. You know, one of the issues that always comes up with license plate readers is individual privacy. And you don't have individual privacy if these records are open. And, you know, that's a policy decision that all of you need to make. But like I said, it's consistent with what other states do. And we believe it's a good policy. Does it affect us one way or the other? The only one that really affects the effectiveness of the device is the location information. And so, you know, if you choose not to close them to the public, then, you know, I mean, that's a policy decision you all can make. That's not our recommendation.
Madam Chair, if I may, just a comment. But haven't we lost our individual privacy with the agency putting the readers up? I mean, it's not just the data that is that's being prohibited from the public access, but the public actually, I mean, your argument for individual privacy, I mean, people have lost their individual privacy when the readers are out there, have they not? I mean, someone's viewing that data.
I think certainly there is a limited loss of privacy, but when it's in the hands of the government for a specific purpose, and it's only accessed for a specific purpose, then there's a balance between that privacy and the good it does with public safety and being able to quickly identify and apprehend criminals and recover stolen property. But when you have it open to anybody can access it, now that furthers the availability of that information on a broader spectrum that I think further raises concerns about privacy. When we get it and it's only available to us, then we have rules on when officers can access that and for specific purposes. And so, you know, we're targeting certain activity. We're targeting when a crime occurs, we'll look at vehicles that are in that area. I know one example that came from Wichita is they had a homicide, I believe it was. It was either a shooting, I think it was a homicide. And they got a vague vehicle description from a witness. And from that, they were able to see that vehicle in their license plate reader system. And from that, got the license plate number. And from that vague description of a vehicle, they were able to identify that suspect and had him apprehended in a matter of a couple of hours. So those are the values. And you know, like all of these things, it's a balance between, and when we're using technology, there's always an intrusion into people's lives. But what's the balance in that, and how do we use that as minimally as we can, that intrusion as minimally as we can, and gain the value of protecting people from criminals? So that's the balance that we see.
I don't disagree with that, but I do believe that the public transparency of being able to view those records could be a major accountability factor for holding accountability to the agencies. And when you take and put the prohibition in place that stops that accountability, I guess, I mean, you could actually go check those records from a public standpoint to see, are we monitoring more in a way to profile the public, to understand their habits, to see what their travel records. I mean, there could be a lot of ways that data could be used by an agency rather than just strictly law enforcement. And I don't know how you would hold them accountable unless, I mean, the public can actually do that work. You know, I don't have the time to sit down and do all that, but someone should. because we need to make sure that the government agencies are using their police powers in an accountable and a fashion that we intend to be.
And I don't believe this bill would limit the access to the public on, say, for example, a report on the aggregate data. What it would protect from is the specific data. And we have a lot of issues where we do that, where there's open records closures of certain investigative reports and criminal reports, and yet we produce aggregate reports that are public accessible. And so I don't think it would, prevent a broader report, kind of reporting on the activity level that we are conducting these at, and a general area in which we are applying these and seeing success with these.
Well, thank you, Madam Chair. Thank you, Ed.
Thank you. Committee, we have information that Proponent Conferee Lieutenant Casey Slaughter from the Wichita Police Department is now on Webex. So with that, we will hear his testimony, and then we will come back to committee questions for any of the Proponent Conferees. So please introduce yourself, Lieutenant Slaughter, and welcome to committee.
Madam Chair and committee members, thank you. My name is Lieutenant Slaughter, and I'm the Auto Theft and Larceny Watch Commander for Wichita Police Department. And I'm assuming everybody can hear me okay?
We can, yes, thank you.
Great. Just want to make sure before I droned on for about 10 minutes. I apologize, I was having some tech difficulties here getting on. So I want to tell you a little bit about the background of our program. I started the program back in 2014. We had a little bit of a limited program due to financial resources back then, but it's grown, of course, to having 7 mobile systems throughout the city. And what those are is just simply we have license plate readers on top of police vehicles that just roam around, looking for those stolen cars or those Amber Alerts and those homicide suspects, as Mr. Plump mentioned earlier. And then we also have one fixed system with that vendor. This has grown recently to, in 2020, we took on a new vendor as well, a secondary vendor, who simply has stationary license plate readers that are around the city, and those are solar powered and very, very modular. So we can move them essentially as crime trends occur. And then as crime trends get resolved, we can take that LPR out of that particular area and move it to another area that may be needing some attention. So in looking at LPR legislation, we looked at a lot of different things, and we reviewed 16 different states worth of LPR legislation, spoke with multiple chiefs, sheriffs, and the license plate reader director at Houston HIDA, which stands for High Intensity Drug Trafficking Area, to come up with what we have now. What brought us here, as Mr. Klump mentioned earlier, is that we weren't getting permitted. This started back in July 6th of 2020 by the Department of Transportation. At that point, we already had a stationary license plate reader on a state-run highway, and we were looking to put the second one up, which was provided to us through JAG grant funds, through federal JAG grant funds. So right now, we don't have that particular license plate reader up and running, simply because we were no longer being permitted to do so. So it's been sitting in storage for a little over a year. Just kind of collecting dust, unfortunately. So we're waiting very anxiously to get that up. And then what we found out that was the issue with the Department of Transportation is that there were no laws in place currently restricting the availability and what is going to happen with the license plate data, and then who's responsible for maintaining that data if requests do come in. So I think this bill appropriately addresses those concerns. So a little bit about some stats that we have, and of course you probably have my testimony in front of you, and I'll give you some highlights, obviously, for the purposes of the record. We started our program, like I said, in 2014, but these stats that you're seeing here are covering all of the stats moving forward from the time of the inception of the program to today. Actually, I'm sorry. Let me rephrase that. Back in November, we started this second vendor license plate reader program, and these stats here are for that specifically. So $2.8 million since November, 110 stolen license plates, 299 arrests. Most of those are felony, 35 guns seized, and we have an outlaw motorcycle gang that was located simply because of a license plate reader alert. And how that happens is, I'll kind of give you an idea. We're not out there looking for random vehicles. We don't randomly search for anything specifically. We have policies in place that restrict this, of course. We go through a very significant amount of training on the department for every single officer who has access or could get access to the system. We have supervisory oversight, and of course we have random and directed audits that occur in our agency. So random meaning, obviously I just go in there and I'll look randomly to see are people following policy, and then directed is if there's some other violation going on, say if somebody were to point me in the direction and say this person has violated another specific policy related to records of a specific nature, and then I would also go and look for that particular person or officer to see if they've done something in the license plate reader system that's not conforming to policy. So a couple of different things. I know in 2019, there is a study that was done by the National Insurance Crime Bureau. And I put this table together that I have here in front of me, but and there's also a newer one from 2020. But Topeka, Kansas was actually number 6 on the table for the most, motor vehicle theft rate using data from 2019 from the National Insurance Crime Bureau. So it's tracking the highest amount of theft rate by motor vehicle by city and state. And so Topeka number 6. The new 2020 study, Topeka has now dropped off, thank goodness, but now St. Joe, Missouri has come on, and they're counting that as St. Joe / Missouri, Kansas, because it's right on the border. So Kansas is certainly very high up in motor vehicle thefts. I can tell you, being the auto theft lieutenant, we have a serious problem in Wichita with motor vehicle thefts. And I get pretty passionate about motor vehicle thefts simply because these are not something that are typically just stolen and driven down to the grocery store to grab some milk and then dropped off. These are used in more major secondary crimes. In almost every single situation, generally, no suspect goes and robs a bank in their personal vehicle. They will steal a car and go and do said bank robbery, and then sometimes they'll steal another one. So a couple of quick stories I'll give you on just the background of what we've seen and some of the success stories. Last year, a 20-year-old man was shot to death by an unknown suspect who witnesses described fleeing the area in a light Buick Rendezvous. Detectives analyzed police records and came up with a series of possible license plate in vehicles outside of the LPR system. They then searched the LPR system looking for a light blue Buick Rendezvous, and they documented one in the area of the homicide within 10 minutes of the crime. They used this information to locate the vehicle and the suspect, who was formally charged with felony murder, robbery, and juvenile possession of a firearm. And then again, another story, officers used ALPR with our agency to locate a VW Passat that was taken in a residential robbery of an 82-year-old female. The victim stated 3 suspects forced their way into her home and knocked her to the ground, causing injury. Suspects took her purse, money, cell phone, and other items before leaving in her vehicle. Officers got a timely license plate reader alert in the area. The vehicle was located and 4 suspects were taken into custody without incident. Suspects were interviewed by detectives, and 1 confessed and implicated the other 3 in the crime. In all, 3 suspects were booked for robbery, and they were later formally charged for burglary, robbery, felony theft, and battery. So those types of stories, I could go on and on and on, and I have hundreds of them. And I know at least 6 homicides in our jurisdiction have been solved through the assistance of license plate reader technology in our entire department. It's been, I will tell you, the most transformational technology that we have ever had in our department. I feel pretty confident in saying that. So again, the concerns are the physical locations of the license plate readers. We certainly don't want the bad guys knowing where the license plate readers are. We also don't want domestic violence stalkers to be able to send up a core request and get information on what their ex is doing. So we want this to be protected and precluded from that. And then let's see. Some of the pros that I want to talk about real quickly is, of course, it's a full force multiplier. In a time where we have very limited staff and limited resources, these are out there searching for these types of suspects and these violent offenders all day, all night, every day, and they never rest. So I feel pretty confident when that, and I sleep very good at night knowing that those license plate readers are out there working hard for us. And then, of course, the objective evidence they obtained. There's no subjectivity to a license plate reader alert. It is what it is. It simply documents a plate on a car, potentially a vehicle description, and there are no live feeds to any of the license plate reader vendors that I'm aware of anyway, at least the ones that we have. So these are not something we get on there and look at video. These are still photo shots of vehicles that travel across these license plate readers. And then back to the core request specifically, the concern just isn't there with our community in Wichita, I can tell you. Of course, there's going to be exceptions to that. But I know this because I go to HOAs, I go to district advisory board meetings, and I go to neighborhood association meetings. And I haven't really had too many naysayers or folks that come back to me and say, oh my God, this is terrifying. I don't want this in our community. What I do have is I have HOAs and businesses reaching out to me personally and saying, how do we get these in our HOA? What's the cost? And can we connect this to your system? That happens all the time. So I feel very confident we have community support. And with that, I would urge you to support the passage of this bill, and I will definitely sit for questions.
Thank you, Lieutenant.
Yes, ma'am.
We have now heard from all our proponent conferees. Are there any others in the committee meeting room or online? Just checking one last time, and seeing and hearing none, then we will turn back to committee questions. And I think Senator Haley had a question, and then Senator Pyle. Thank you.
Thank you, Madam Chair, and thank the proponents for bringing the measure before us today. Part of my concern with this measure has been addressed a bit by Senator from Brown, Senator Pyle. It's about the use or the systemic use of this data, and then how it might be used not only between other departments or the access where it's necessary, as has been represented. And I appreciate that. If, let's say Wichita Department were to have this reader in place, but then Topeka was looking for a specific make or model, there is that interchange, and that would not be disaffected by this. I guess my concern goes to not where there's a legitimate interactivity or use or disclosure among law enforcement, but where that data, and of course the extreme of the other side for the private use that was detailed, the stalker wanting to know where somebody is and tracking somebody. But my specific question is, the concern that I have with these readers is where there might be some systemic and designated use to target an individual or groups of individuals, and where that could be shown, that pattern and practice by law enforcement to so profile, and the access to the data in its aggregate form be prohibited because of this bill. I'm reading through, I'm trying to understand if that were to occur or how that might occur. Specifically, I remember this discussion from the identification before long ago of what a gang was, Madam Chair. They were saying that by wearing a certain clothing or being in a certain area, that there would be surveillance done on that entity or entities, and they would then be so designated as a gang where such may not exist. So my question here, and I know I'm taking a long time to get to it, and I apologize, but is there an opportunity here in this bill to prohibit the showing of systemic use by law enforcement in the tracking and designation of a particular person or group of persons, where it might be shown to the contrary because they can access the data? Chief Klump, maybe, does that make, do you understand my concern and this question, and are we prohibiting it if this bill is passed?
Please go ahead and introduce yourself, and thank you.
Ed Klump with the Associations for the Sheriffs, Chiefs of Police, and Peace Officers. Yes, Senator, I do understand where you're going with this, but keep in mind this is collecting license plate information. It is no way collecting any information based on race, ethnicity, clothing, lifestyles, or anything else. As Lieutenant Slaughter indicated, these readers are generally put in places where we're having a crime issue. And it's not based on any other factors. We have limited resources to obtain these devices, and we put them where they're going to be most effective. And we're trying to address crime, so we put them where crime is occurring. And I don't know of any way to measure other than looking at aggregate data, maybe perhaps of where the license plates have been, or license plate readers have been placed over a period of time, and comparing that to where the crime issues are that we're trying to address. I mean, those kind of aggregate reports would be possible. But I don't see how these can target particular people, because that's the only way that we get alerts on these is if the license plate itself has been entered in the system for that person being wanted, that person being a missing person, that person being on an Amber Alert, or that vehicle being stolen, or, it's an investigative tool that we use, and it collects enough license plates. You can't just go down through it and say, well, let's just see what's interesting. You have to be looking for a particular license number or a particular vehicle. And as Lieutenant Slaughter stated in his homicide case, that they had the lead of the type of vehicle. They got some information on some possibilities that could be. From that, they got the license plate information, then they run that through the system to see if any of those were in the area of the homicide. So that's the way they're used, and I think they have a very low probability of being used in the way that you're concerned with.
Thank you, Chief Klump, and thank you, Madam Chair. Are these fixed items? I mean, I know like when you go through the K tag, they have them already through our Kansas toll pipe. They have them already. But are there mobile systems? I mean, is there one that can be carried around in a car, so to speak, and be mobile, like in a vehicle?
All of those things. I mean, we have systems that are fixed. For example, along the turnpike, there's places where we have license plate readers that are continually finding stolen vehicles and wanted persons coming through our state. We also have some, I think Lieutenant Slaughter described some that they have that are portable, that can be moved from one location to another. And there are those that are actually affixed to police vehicles that will check the tags surrounding the vehicle for wanted persons and stolen vehicles and things like that.
I'm genuinely supportive. It would be my concern about the portable ones, those that are mobile, that can be taken to different areas and how that might be used. But I appreciate it. Thank you, Madam Chair, and thank you, Mr. Chief Klump.
Thank you. Senator Pyle?
Thank you, Madam Chair. First, I have a couple questions for the reviser. I need to understand, is the prohibitions in this bill, are they limited only to state and federal requests, or would it cover all municipalities, all requests from the public?
Mr. Thompson?
Thank you, Madam Chair. Jason Thompson with the Revisor's Office. So I think you look to the definition section for the Open Records Act, because again, this is all just part of the Open Records Act. And you start with public agency, which is what on page 2, it becomes subsection K, I guess. That's the state or any political or taxing subdivision of the state or any office, agency, or instrumentality thereof, or any other entity receiving or expending and supported in whole or part by the public funds appropriated by the state or by public funds of any political or taxing subdivision of the state. And then there are a couple exceptions to it. It doesn't include someone who receives funds, entity solely by reason of payment from public funds for property, goods, or services, or any municipal judge or other judges. So they're excluded. So public agency broadly is basically what you would think of, all state entities and also some state associated entities because they receive funds and also have state records, right? And then the public, of course, is, you and I, right? We're the ones that make the request. And so it doesn't, I think that gets to your question.
Yeah.
At least part of it.
Pretty much covers.
Okay.
I mean, it's very broad. And my second question would be in the bill under public. The definition of public include the press?
Mr. Thompson, thank you.
Madam Chair, Jason Thompson again. Yes, the press often makes requests under Quora, yeah.
So they would not be able to. Okay. Madam Chair, I think it'd be interesting for this committee to get the information on how many Quora requests have been made in the past 2 years from all these entities that are in the bill, whether it's municipalities. I see the League of Municipalities as a proponent. But, and the reason I draw attention to these things is, Mr. Klump, in your testimony, you basically, the issue has resulted in the Kansas Department of Transportation suspending allowing any license plate reader systems to be installed on state or federal highways. That ought to concern every one of us in this committee when law enforcement is being held back from doing their job. They've suspended allowing them. You know, I hear a lot about safety from that agency, and now here I'm reading where they suspended law enforcement. And rather than what I believe this committee should be doing is saying to that department, you cannot do that. You cannot suspend it. Instead, it's a reach to instead deny the public access to the records, which I don't see. I'd like to see the arguments and the actual presentations where a public, under this definition, misused that information, or it was used for abuse, or it was used for stalking, where it was used for, I mean, I hear about it, but I'd like to see the documentation. But I do believe that we ought to be looking at saying that you cannot interfere with law enforcement and the gathering of this information for these purposes, and you cannot suspend that activity. So that you will, just because you don't want to provide those Quora requests or there's an expense to it, you're suspending law enforcement. That testimony right there, written in front of us, ought to concern us. And instead of going after John Q. Public, maybe it's the agency, but no, instead we're going to give all the freedom back and the liberty to the agencies so they don't have to fulfill Quora requests when the freedom belongs to the people. They should be able to make these requests. And if they're doing something that's wrong, they'll get caught. So anyway, that's just, Madam Chair, just some comments. And but I appreciate, Jason, thank you for the response and answering those questions. And I just have some concerns with this bill. Thank you, Madam Chair.
Thank you. Committee, other questions? I have a few questions for either Mr. Klump or Lieutenant Slaughter. I'm understanding that I just want to make sure that the committee is clear and that my understanding is clear as well, that the information gathered by the license plate readers is a picture or a photograph only of the license plate and the car. It does not include a photograph of the driver or any passengers. Is that correct?
Madam
Go ahead,
Chair,
Mr.
Ed Klump, Association of Chiefs of Police, Sheriffs, and Peace Officers. My understanding is that they are capturing basically the view of the vehicle and the license plate. And it depends on the device that's purchased. Some only store actually they read the license plate and then that's what it stores is what it reads. Some of them most of them will store the image of the license plate. Some of them will have the image of the vehicle. Some won't. But it's limited in what it stores.
And it's aimed at the license plate, correct?
That's my understanding, that it's primarily the vehicle and the license plate.
Because I understand the balance that you were
Yeah.
talking about, Mr. Klump, that the balance between, law enforcement and public safety and the balance between individual privacy. And I think we as the legislature try to find and strike that balance.
Sure.
Another question was, we heard a lot about the process and the procedure for using the data that's collected by the license plate readers. Am I correct that the data is only looked at later if there's a specific purpose? We had information that at 10 o'clock at night at this intersection where we happen to have this license plate reader, that there was a suspect or a vehicle used possibly in criminal activity at this location. Let's go look to see, or am I correct that it's directed information like that, and it's not just a, let's go scan, see what came in today?
That's correct. There is so much data collected, from every vehicle going past that it would be impossible to just scan through it just to see what's there. We either are looking at the specific data because it has triggered an alarm that tag is entered in the system as being a one-person stolen Amber Alert, et cetera, or in the case of the homicide investigation, they had a series of vehicles that potentially matched the description that was given. They had the license number of those vehicles, so then you go back, were any of those license numbers in that area at that time? And then the license plate reader was able to say, yes, this one was, but the others weren't. And so that focuses our investigation then in that direction. Doesn't mean that's the person, but it focuses our investigation. And in that case, it was the person, and we were able to recover evidence for suspects and make charges.
And this was actually brought forward to enhance individual privacy so that the public at large couldn't look at or request the information and to use it for other bad purposes.
That is our intent. We don't feel like it's in the public interest for a person to be able to come in and say, run the license plate of their spouse or their ex-spouse, or like Lieutenant Slaughter talked about, a victim of a stalking case. We have so many of those domestic violence related and domestic issues where spouses continue to try to track the other spouse in an effort to harass them. It comes in play in child custody cases. We see those kind of issues all the time. Now, I don't know how many of those are resulting in court requests, and I don't know how we'd ever tell that. But those are the kind of things that we feel concerned about that this would address if we can get this bill passed.
One last question. If an individual needs the information, hey, was this license plate at this address at this time? For instance, in a court case, if there's litigation about custody or divorce matter, or even a criminal case as well, the suspect was alleged to be in this vehicle at this time at this place.
Right.
Can this information be obtained through other processes, such as subpoenas?
Yes.
By an individual, not by the public at large, if you could address that.
I believe it could be, and I think that goes back to Senator Thompson's question earlier. And absolutely, in a court proceeding, whether it's civil, domestic, whatever, the court can issue, a subpoena or for the information or a search warrant, whichever they do, and ask for that information on a specific vehicle, and that would certainly be allowed. And that we have that apply in numerous things that are protected in the Open Records Act, such as our offense reports. Sometimes there's information that is sought through a subpoena for information that we may possess that otherwise is closed to the public. And so the court always has the right to order disclosure of information.
The court, at the request of the individual involved in the court case, an individual
Right.
could request the court to issue the
So one of the parties in
subpoena.
a case would request the court to issue a subpoena for this information and would demonstrate to the court it's relevant to their case.
Thank you. A question then for the reviser. Actually, a question for research. Is it possible to determine, we did have a question, we heard from Mr. Klump that they wouldn't have any ability to know how many CORA requests have come in about this information? Is there a way that, given some time, you would be able to determine that, or?
This is Natalie Nelson from Legislative Research. I can definitely look into that and see if that's available.
Thank you. Senator Pyle, you had a question?
Thank you. My question's for the reviser. And I know this might be a tough one, but it might be easy for Jason. Is there anything in the statutes of any criminal, civil penalties for wrongfully using this sort of data?
Mr. Thompson?
Thank you, Madam Chair. Jason Thompson, Revisor's Office. I'm having trouble thinking of a crime right off the top of my head. Let me check with some of the representatives and see if there's any crime we could come up with that a prosecutor could use. My hesitation is because part of it would depend on how you acquired it, right? If you maybe acquired it under false pretenses, that's one thing. If you acquired it as a legitimate records request, it might be what you did with it after that and whether that was somehow criminal. So some of it's fact dependent, but I can't think of any crime right off the top of my head.
Thank you. And I'm just curious because if there is no crime, I mean, it just seems to me like we're going after the wrong target here in this bill. We're going after withholding records from the public when maybe we ought to make it more stringent, a greater penalty. If there isn't one, there should be for wrongfully using the data. And number two, prohibiting the agency from limiting law enforcement from doing their job. I'm just trying to analyze this whole situation, and that's kind of where I come to a conclusion that that's what needs to be done rather than prohibiting access to the records. Thank you, Madam Chair. Thank you, Jason.
Thank you. Do we have any neutral or opponent conferees in the committee meeting room or on Webex? Seeing and hearing none then. Thank you everyone for your testimony today that you have provided. We appreciate that, and we will close the hearing on Senate Bill 434. And we will then open the hearing on Senate Bill 435, expanding law enforcement officers' jurisdiction to include situations when an illegal act is observed that the officer reasonably believes will jeopardize the safety of any person without immediate action. And a bill brief from our reviser, Mr. Thompson.
All right. Thank you again, Madam Chair. You guys are keeping me busy today. Senate Bill 435 does expand some law enforcement officer jurisdiction. The two statutes in the bill, the first is the main piece of this, KSA 22-2401A. That is, of course, in our criminal procedure statutes, Chapter 22. And it currently provides law enforcement jurisdiction for a number of officers that are specified there in the statute. Everyone from folks employed by the county or a city or a Native American Indian tribe, et cetera. So there's a whole list of the law enforcement officers, and they each have their own subsection with specific powers and jurisdiction listed. So the main thing that I did in cleaning up this statute as I was drafting it and working with the requester, who's here to testify next, was to make sure that the language was consistent in each subsection, using the same sort of terms and doing what we strive for, making it consistent within the statute. And also to consolidate some provisions that were repeated in some sections and not in others, but should apply to all of these law enforcement officers in the eyes of the requester, right? These are powers, for example, when you've been requested to assist in another jurisdiction, some of the officers had that listed, others didn't, and that could create a problem. Unless there is a policy reason for a difference, you're asked to apply those powers to all of the law enforcement officers listed here, and we do that by putting them in one subsection, Subsection H, a little further down. So you'll see some things are removed as you go along, and then they're consolidated kind of later because they apply to all of the subsections. And then there are a lot of other little language changes that just make it consistent as best we can throughout the statute. So let's jump then to Subsection H, which is the bulk of my bill brief and the bulk of the bill, honestly, which is on page 6, right in the middle of the page, line 24, and then on to page 7, we get some other new language. So this is the subsection that will say for all law enforcement officers that do not otherwise have, statewide jurisdiction, they will be able to have their powers and authority as law enforcement officers anywhere when a request is made for assistance from the area where they're asked to go. 2, they're in fresh pursuit of a person. 3, they're transporting persons in custody to an appropriate facility. And 4, when they're investigating a crime that occurred within their jurisdiction, and they appropriately notify and coordinate with the local agency with jurisdiction where they're going to conduct their investigation. My recollection, and hopefully the requester and proponent can clarify this, is that at least 3 of those are current law. There's some question, I recall, about one of those not being clear for at least one type of officer. And when they went to do an investigation, they ran into a court case that said you didn't actually have authority to go conduct that investigation in that other jurisdiction, and that led to an exclusion of evidence as not being a valid exercise of the law enforcement officer's powers. So you can see why it's important that all these are there, right? If your policy is you want them to have these powers, you have to clarify their jurisdiction, or it has consequences when that officer goes and does something and they later find out they didn't have jurisdiction to do that act. It can lead to evidence exclusion, it can lead to cases being lost, et cetera. So I'll let the proponent get into a little bit more of that, but I want to sort of set the table. That's the four pieces there. Again, some current law, some may be an expansion of law with relation to certain officers. And then new subsection I is the other new provision that is not current law, and so I wanted to highlight that for you too. It's in the bill brief as well. So in addition to the jurisdictional authority that they get under this section, or maybe there are other provisions of law that relate to them as officers, all law enforcement officers would be allowed to exercise their powers and authority when outside their described jurisdiction, when an illegal act is observed that the officer reasonably believes will jeopardize the safety of any person without immediate action. And so that's sort of that exigent circumstances kind of thing, right? You see a clear and present danger, that might be some other term you've heard. That's the concept, right? And the qualifications to that are listed there in the statute. They have to be in a certain status or traveling related to their law enforcement duties. They have to report their activity to their agency in their own jurisdiction. They have to remain where they see the activity and cooperate with the other law enforcement agency that has jurisdiction there. And there could be other restrictions imposed by their own agency on where and how they use these powers. But at least it's there jurisdictionally that they can do this. And the last thing I'll highlight is Section 2 is in the bill only because it has a repetitive and redundant provision. So KSA 72-6146 is about school security officers and campus police officers. They are covered under 22-2401A. The provision that talks about their powers is covered under that other statute. And there's no need to have it in both places. It actually can create confusion and conflict if we amend one and not the other. So the recommendation is to remove subsection D over there in 72-6146 just to avoid that issue and consolidate everything into 22-2401A. But no change substantively to their powers or duties, just a statutory cleanup almost to be consistent. That's more than I intended to say, but we'll see if you have any questions.
Thank you. Committee, any questions for the revisor? Seeing none, then we do have limited time. Want to make sure we hear from both our conferees and have time for questions. So we're going to ask for a 5-minute limit on each of the 2 in-person conferees that we have, and that leaves us time for some questions. So with that, Mr. Klump, please introduce yourself and welcome to committee again.
Thank you, Madam Chair. Ed Klump with the Association of Chiefs of Police, Sheriff's Association, Peace Officers Association. We brought this bill. This is very important to us. We're running into issues with loss of court cases where arrests are made or evidence is collected in conflict with the inconsistencies or based on the inconsistencies in the statute. This statute is developed over time with a lot of amendments to it over the years, and I think that's what's unintentionally created these inconsistencies. Jason did a good job of explaining what those are. One thing I would point out that this statute is talking about certified law enforcement officers. Everybody listed in this statute has to go through KLETC and they have to be certified by CPOST. We're not talking about any other person that might be viewed as a law enforcement officer. If they're not certified, they're not covered under the statute. The statute currently covers county law enforcement, city law enforcement, tribal law enforcement, university police, campus police, adjutant general law enforcement, and horse thief reservoir police. So those are the ones that are covered in this. They're all non-state agencies. State agencies have their own specific statutes for each one that authorizes them and explains their jurisdiction. And so those are not covered in this. So there are 3 areas, as Jason mentioned, that are currently covered in law. One is that any place where another law enforcement agency requests assistance when in fresh pursuit, and when transferred in person in their custody. That doesn't just mean a person arrested. It could be a mental health person going to a state hospital. It could be a juvenile being taken to a facility. And the problem is not any one of those listed agencies has all three of those listed. And so when courts look at that, when they say, okay, legislature, you have specifically authorized this agency to do this, but you didn't authorize it over here, they interpret that to mean that you intentionally are saying this agency over here does not have that right. And so that's where the problem comes in. So we have had cases where, for example, well, let me go through something else here. So, for example, county agencies, city agencies, tribal, university police are not granted jurisdiction when transporting persons in their custody. And who does most of that transporting? Counties and cities. But we don't have that in ours. And campus police are not allowed to assist another law enforcement agency upon request. And you'll hear from another proponent on that. Tribal police lost a case because they were in fresh pursuit of a felony suspect. They apprehended the person outside of their jurisdiction, and the court said, you don't have the right to fresh pursuit in this statute. We're going to dismiss this case because that was an unlawful arrest. Those are the issues we're running into. And so Jason pointed out where you find those things now, and they will apply consistently. And then the new extension that is on page 6, lines 32, 35, dealing with when we're investigating crime. That came up in a Johnson County case where a person was a victim of a crime in one jurisdiction, lived in another. They went to their home jurisdiction to report the crime. They said, well, you need to report it where it occurred. They went and reported in the jurisdiction where it occurred. That agency's investigating. The other agency's aware that this investigation is going on. That investigator goes into the home jurisdiction of the victim to talk to a person of interest, not knowing that they were going to turn out to be the suspect, not knowing that they had electronic evidence that would be seized. They seized that evidence. The court threw it out because he wasn't within his jurisdiction. And so those are the kind of things we're trying to prevent here. And so that clarifies that if we're doing an investigation, we go outside our agency, and this happens every day within counties. A Topeka officer going into Shawnee County to talk to somebody. It just happens all the time. And so this will cover that. The only thing this will require is that we notify that other agency we're there. We feel that's important because sometimes somebody's not sure it's a law enforcement officer, and what do? They'll call 911. Is this really a law enforcement officer at my front door? We feel those people need to be advised of that so they can answer that question. And then finally, the new section on I. Here's the situation we're in. We are oftentimes traveling outside of our jurisdiction, going to training, coming back from training, coming back from picking up, dropping off a prisoner, going to pick up a prisoner, going to meetings, whatever. And we are driving down the streets and highways, and we come across something that is going on in our view that we know is a crime. It may be a violent domestic taking place on the side of the road. It could be a carjacking taking place. It could be any number of things. And we don't want to expand the authority, just carte blanche. We want this to be a very limited expansion of authority, that if we have an officer who is on duty or is in a police vehicle and they're properly identified, then they can, if they have reason to believe they need immediate action to stop that act, then they have the jurisdiction and the legal authority to do so, but also have the requirement to, as soon as possible, notify the agency with jurisdiction. You stick around and assist them in the investigation. You write reports. You report it to your own agency. And one final important step in that is we reserve the right of every agency to limit that authority if they choose to upon their own officers. And so all of these are very important things to us. That last one is a big issue on liability for us. Nobody would expect us to drive by an incident like that and ignore it. Nobody would expect us to just pull over the side of the road, call it in, and sit there and watch. And yet, if we take action under the current law, it increases our liability. Madam Chair, I probably went over my 5 minutes, but I tried to talk fast.
A little bit, but thank you. That's very informative. Appreciate that. Then we will invite Dan Carney, Director of Safety and Security, Chief of Police, Blue Valley School District Campus Police Department. Please introduce yourself. Welcome to committee. And my Senate district includes Blue Valley School District. So it's good to see you here and to hear directly from you. So thank you very much. Go ahead.
Thank you. Dan Carney, and I'm Director of Safety and Security for Blue Valley, but I throw in the Chief of Police because I'm a commissioned law enforcement officer and head of the Campus Police Department for Blue Valley. I worked for the Overland Park Police Department for 26 years and retired, and then came to Blue Valley in this capacity. But I remember when I was with Overland Park being thrilled. It was really early in my career, and all of us were, when this piece of legislation went into place, and I can't tell you when it was, that extended our jurisdiction if an outside agency requested help. And it kind of cleared up some muddy waters for us at the time. And I remember we all were like, oh, this is good. If Leawood Police needs Overland Park Police, they just say, hey, we need your help. And we're there and we're empowered. And that was wonderful. So I came to Blue Valley. I had the Blue Valley Campus Police Department, again, all certified commissioned police officers, police department. And I mistakenly made the assumption that we were operating under the same guideline or law. And it was only a few years ago when I discovered that we're not, that we don't have that ability to assist as empowered police officers if requested. This issue kind of applies in minor circumstances and maybe perhaps more major ones and things that have never happened. One of the things that occurred, I was at the Overland Park Police Station, and Major Keith Jenkins, who was in charge of patrol, asked me, hey, could we possibly use a few of your officers to double up with ours? They had an officer killed, Officer Mosier, who was killed in the line of duty, and they had so many officers going to the funeral and doing different things. He said, we could really use your help. And I said, we cannot help. We don't, even upon your request, we don't have that jurisdiction, despite the fact that I have tenured, well-trained police officers working for me, 2 of which came from Overland Park Police. Then I started looking at things like something as simple as a homecoming parade that goes from the Walmart to the high school. And of course the police department calls me and says, hey, could we use some of your officers to block these intersections? And I said, I can't put them out there as police officers. They're not empowered. And so it kind of, the conversation went from there. I talked to the chief of police of Overland Park, and I said, you know, if we had a tornado rip through Overland Park and you needed some help securing a perimeter around the damaged site, we would not be empowered if we were requested to help you. So really, my point in being here, I've kind of got the more narrow piece of this, is that we just want to be a good partner. We're not always going to be available if we're asked to do something by one of the local agencies. We're not going to be available. Our primary focus is in the schools and the safety of the schools, and that's where we put our attention. But I've seen it happen before where we are needed, and we have stopped to help. We have an officer who drives one of our marked cars. He's the liaison to all of our elementary schools, and he's back and forth all day long through the city, and he'll stop to help on an accident, maybe direct traffic until the city police can arrive. But again, he's not empowered to be out there directing traffic. So this is just about us wanting to be a good partner to our agencies. They are so awesome to us that we want to be able to reciprocate when needed. So I'll stand for any questions. Thank you.
Thank you. Before we get to questions, are there any other proponent conferees in the committee meeting room or online? Not seeing any, then we will open it up for questions for either of our conferees from the committee. Seeing none, then, yes, Senator Haley.
Thank you, Madam Chair. It just came to me. So intrastate concerns me. We're on a border with Missouri, and I'm just wondering if there is a reciprocity for deputizing, again, or impaneling those who might have, who might come over. And I know it's referenced in the bill, But are they doing anything along this line? If you're aware that they'll be granted similar power to draw some of our law enforcement or related agencies in intrastate?
Mr. Klump, if you're available to answer that.
Thank you, Madam Chair. Ed Klump, Kansas Association of Chiefs of Police, Sheriffs, and Peace Officers. There was a bill that we introduced several years back, probably 5 or 6 years ago now, specifically addressing the across state lines issues for the border counties and the border agencies, because it's not just in the Kansas City metro area. It can happen between Coffeyville, Kansas, and South Coffeyville, Oklahoma, and other places around the border. And it specifically addresses that. It's a little trickier because you have people that aren't trained in Kansas law enforcement standards, and Kansas law enforcement are trained in Oklahoma or Missouri standards. And so it's a little trickier how we deal with that. But there is a statute in place now, thanks to you all passing that legislation, that specifically addresses how we assist each other across state lines.
But will they be doing or offering similar opportunities, I guess, for our law enforcement in any of the border states, Missouri included, or is theirs a little more stringent? This is, as you know, a departure, and so I just didn't know if there was any other such potential reciprocity.
It won't be this language. It's the language of the other statute, and it addresses that. Missouri passed a law very similar to ours at the time that bill passed to assure that Kansas law enforcement had the same rights. I don't know if Oklahoma, Nebraska, and Colorado have done the same or not. I can tell you nobody has brought it to our attention that we're having any issues with it.
Thank you, Mr. Cole. Thank you, Madam Chair.
Thank you. Yes, Senator Pyle.
A real quick question, easy for, I think Ed can answer. You mentioned Horseleaf Reservoir law enforcement. Are the same requirements on those entities for insurance liability, et cetera, like we do with the tribes and we do with other law enforcement? Are they going to be required to carry that kind of liability?
There are specific places in the statute, and Jason could probably address this, that it specifically talks about liability. I think that's with the tribal. I don't think it's with the others. My recollection is the Horseleaf Reservoir Police is a police agency belonging to a public entity that operates Horsetooth Reservoir. And so as a public agency, I think they would fall into the same civil liability requirements of all of those government entities.
Committee, other questions? I don't see any. I want to specifically thank Mr. Klump for his testimony and Mr. Carney as well. I'm hearing that in schools, possibly because of more at-home learning or virtual learning or other pandemic responses, that there has been some difficulties at some of the schools with some increase in incidences. So it's good to have a presence there with law enforcement to keep law and order in place, if you will, and appreciate that effort, because I know that these last 2 years, particularly on our students in Kansas, has been very difficult, and for parents with school-age children as well. So I'm glad to see you here involved with this process, and if you can, I'd be glad to talk with you after committee as well. Committee, want to direct your attention to your folder. We do have Proponent Conferee written testimony from John Goodyear, General Counsel, League of Kansas Municipalities, and also Greg Smith, Special Deputy Sheriff for Government, Veteran, and Crime Victim Affairs, Johnson County Sheriff's Office. So with that, committee, I know we had planned to work a bill, but we had some a good debate and discussion on the 2 bills we heard today. We will now ask for neutral or opponent conferee testimony in the committee meeting room or online regarding Senate Bill 435. Seeing and hearing none, we will thank everyone for their testimony and their discussion on Senate Bill 435 and close the hearing on that bill. And we have run out of time to work bills, but please be prepared to do that tomorrow. Friday as well, committee, we will plan to hold our committee meeting to get through working some bills that we have been diligently hearing. With that, I thank everyone for their time and attention today, and we are adjourned.